Good morning, one and all. So, today, that is in part 2 for 50 important questions on SEBI legal that we are going to discuss. In the last live session, we had discussed first 15 set of questions, and today we will cover another 15 set of important questions that hold a lot of importance from exam point of view also, and also it can be a good content revision for you all as exam is very nearby, and I know that you people are very tensed as well. So just stay calm and participate in a healthy discussion that we are going to have today. Contribute by your answers as well. Okay, so let's start with the first question that I have picked for today, which is from Constitution. Which of the following is legislative power of the President? The options are power to grant pardon, power to commute sentences, power to promulgate ordinances, power to lay annual financial statement before Parliament, and all of the above. So, what do you think? Which of the following is legislative power of the President out of all these powers? Or are all of these powers legislative power, or any of one of them? Any guesses? So the answer will be C, that is power to promulgate ordinances. Power to promulgate ordinances is guaranteed under Article 123 of the Indian Constitution, and it is a legislative power of the President. President is the head of the Union Executive, but he also has certain legislative as well as judicial powers. So, power to promulgate ordinance is a legislative power that is there in the hands of the President, and that ordinance later when and this power is when the Parliament is not in session. Okay, only then the legislative power of making an ordinance lies with the President. Now, going on to the next question that we have. This is from Indian Penal Code, that is criminal law, which also holds a lot of weightage and importance for SEBI. There is no right to private defense against which of the following as per IPC? Options: a public servant acting in good faith, a child, an insane person, a person of unsound mind, a lunatic. So out of all these people and their acts, against whom, against which act there is no right of private defense? So the answer will be whether it is against a child that we cannot exercise right of private defense, whether it is against an act of public servant. Okay, so the answer will be A. Section 99 of IPC itself defines the exceptions that are there to the right to private defense, and right to private defense cannot be exercised against persons who are acting in good faith and under a direction of law. And rest of the answers, rest of the options, that is a child, an insane person, a person of unsound mind, a lunatic, all these options are not covered under the exceptions to right of private defense. Right of private defense can still be exercised against the acts of all these persons, whether it is a child, whether it is a person of unsound mind, or anybody else. Okay, so going to the next question that we have, question number 3, that is consequences of absence of complainant are. This is a question that we have picked from Criminal Procedure Code. Suppose the complainant itself is absent. Suppose the complainant itself is absent. So, what can be the consequences of his absence upon his complaint? First, the complaint is dismissed in default, whether the accused is discharged immediately, whether in compoundable cases accused are discharged, whether it is both B and C, that is accused is discharged immediately and in uncompoundable cases accused is discharged, or whether there is no effect under criminal law if a complainant is absent. So the answer will be C. In compoundable cases, only accused can be discharged. It's not that there is no effect at all in criminal law for the absence of complainant. Like in civil law, we have dismissal in default, but in criminal law also, it is not that there is no effect completely. In compoundable cases, an accused is discharged. And the answer will be C. As per section 249 of CRPC, in compoundable cases only, absence of complainant discharges the accused itself. Criminal offences are classified into compoundable, non-compoundable, and compoundable offences are the ones that can be compromised, which have a chance of being compromised. So in those cases, complainant can agree to take back the charges that are levied against the accused. They are actually less serious ones rather than the non-compoundable ones. So in these cases, if the complainant is absent, the consequence is that the complaint is in compoundable cases, accused is discharged. Next question. Which of the following is not an interim order? Now it is a question from Civil Procedure Code. We have various orders that are listed which can be issued by a civil court, and out of all these options, which is not an interim order? Now there are many questions which are asked in the negative, so we shouldn't be in a hurry while answering these questions. We should always be cautious while we are answering such kind of questions, and be careful what is asked, whether it is not an interim order, and then we should answer. So in this question, commissions, temporary injunctions, interlocutory orders, payment in court, order for rejection of plaint. Out of all these, let me know which of the following is not an interim order. So, commissions are interim orders, temporary injunctions are interim orders, payment interlocutory orders are interim orders, payment in court is also, but the last option is the correct answer, that is order for rejection of plaint, which is always a final order and it is not an interim order because it is for rejection of plaint, and once the rejection of plaint and it is not an interim order. So let's have a quick look at and have a quick revision about what is an interim order. An interim order refers to an order that is passed by the court during the pendency of a suit or proceedings to ensure that the interest of the parties to the litigation are not harmed and the subject matter of the suit is maintained. So such interim or interlocutory orders are of temporary nature as they are interim, and the court may pass interim orders in form of commissions, letter of requests, and all these temporary injunctions. All these are actually described here. So rejection of plaint is not an interim order. Next question. Where any electronic record purporting or proved to be -years old is produced from any custody which the court in the particular case considers proper, the court may presume that the digital signature which purports to be the digital signature of any particular person was so affixed by him or any person who is authorized by him this behalf. So this is a question regarding an evidence, electronic record evidence. This is from the Evidence Act. Let me read the question once again for everybody because it is a lengthy question. Where any electronic record purporting or proved to be dash years old is produced from any custody which the court in a particular case considers proper, the court may presume that the digital signature of any particular person was so affixed by him or any person authorized by him in this behalf. So how many years old electronic record document can be considered in such a case? The options are 5 years old, 10 years old, 12 years old, 30 years old. So we have the answer as A. Section 90A of the Evidence Act provides for a presumption as to electronic records that are 5 years old. There is a specific presumption for it which is given in section 90A of the Indian Evidence Act, which specifically provides for the entire statement that has been picked up from this section itself and provided in the form of a question. Okay. Coming to the next question, which is regarding recovery of possession of movable property. So this is from which act? Can anybody guess from which act it is? It is of course from civil law, but which? So it is talking about section that deals with the recovery of possession of movable property. So anybody just guess which act it is quickly? And the sections are listed here in the options. Is it 1 and 2? Is it sections 3 and 4? Is it section 7 and 8? Section 9 and 10? Section 12 and 14? So which sections and which act? And the act possession of movable property. Take note of it. They are specifically asking about the provision for recovery of possession of movable property. I would suggest that some of the important sections also you should keep in mind, because such kind of questions which can be regarding section numbers can also be asked if at all the area from which those sections are picked holds a lot of importance or has something which can be tricked. So just try so we need to answer sections according to that. And yes, the act is Specific Relief Act, which has been guessed well by one of the attendee, and the answer will be C. Section 5 to 8 deals with recovery of possession of property entirely, and out of that, immovable as well as movable property, we have specific sections. Section 5 and 6 deals with the recovery of possession of immovable property, and section 7 and 8 deals with the recovery of possession of movable property. Okay, let's go to solve and quick if we are well versed with the provisions. So take note of such kind of questions and prepare yourself well for such kind of questions also, because they can be scoring for you all if at all you are well versed with the provisions and well prepared. So the next question is, what is the minimum support that is required to introduce a no confidence motion in the Lok Sabha? So this is relating to constitutional law, somewhere around it rather, because it is not asking that whether you can introduce a no confidence motion. Of course, we all know that you can introduce a no confidence motion in the Lok Sabha, but what is the minimum support that is required to introduce a no confidence motion in the Lok Sabha. 8 of Lok Sabha rules, that is the 16th edition, provides for that. The House debates and votes on the motion, and if a majority of the members of the House vote in favor of the motion is passed and the government is bound to vacate the office then. Okay. Next question. Question number 8. Which of the following dispute is not arbitrable? Now this is relating to arbitration. In the last set of questions, we had a question on arbitration agreement. Now we have a question on arbitral dispute. Now this is something which is very basic question, that what can be referred for arbitration and what cannot be referred for arbitration. So the options are a criminal offense, a matrimonial dispute, a guardianship matter, a testamentary matter, or all of the above. So this is actually rather a very easy question, very conceptual and a logical question. Of course, out of all these disputes, the answer has to be all of the above, because arbitration has has specifically provided that the disputes that should be submitted for arbitration must be arbitrable, and the ones which are arbitrable are disputes that the law retains exclusively for the court, and these are the ones which are provided in the all the options. Criminal offenses, of course, not arbitrable. Matrimonial disputes, of course, not arbitrable. These are more related to industrial disputes. For an example, contractual disputes. Such kind of disputes are arbitrable. Next question. Which of the following is an external aid for interpretation of statute? Now, interpretation of statute holds many important areas, out of which schools of jurisprudence, that's for jurisprudence. For interpretation of statute, aids of interpretation are very important, and this question is for external aid of interpretation. So we should know what are external aids of interpretation, what are internal aids of interpretation, so that we can answer such kind of questions well. And the options are parliamentary decisions, historical background, use of foreign decisions, both A and B, all of the above. So which of the following is an external aid of interpretation of statute? Answer is historical background. Historical facts and circumstances that form as a form of external aid surround the legislation is necessary and quite useful in understanding the subject matter of the statute and thereby to arrive at the legislative intent. So it is basically an external aid of interpretation of statute. Question number 10. This is from Companies Act. Company law holds a lot of weightage for SEBI. So be careful while answering such questions. One-person company shall have minimum of dash directors, as this is a very direct question from the Companies Act. Such direct questions can also be expected. Of course, we have a range of questions from easy, moderate to difficult level. So questions of all kinds are expected. Prepare yourself from all angles. The options are minimum of 3 directors, minimum of 1 director, minimum of 15 directors, or else there is no such requirement at all in a one-person company. So the answer is B. Section 149 of the Companies Act specifically lays down the minimum number of members of directors that are required in a company. So this table specifically describes in short that company may appoint more than 15 directors after passing a special resolution, and the maximum directors is always 15, not minimum. For a public company, minimum is 3 directors. For a private company, minimum is 2 directors. And for a one-person company, minimum is 1 director. We can relate it like one-person company is, of course, having a minimum of 1 director. Next question. What are the companies on which the provisions relating to prohibition on its from public, Section 73, Clause 1 of the Companies Act 2013 do not apply? So, what are the companies, the class of companies on which the provisions that are relating to prohibition on acceptance of deposits from the public, that is provided in Section 73, Clause 1 of the Companies Act 2013. These provisions don't apply to which companies? So, banking companies, non-banking financial companies, non-banking non-financial companies. So, the answer will be what? Either it is only banking companies, either it is both banking as well as non-banking financial companies, it is both non-banking financial companies and non-banking non-financial companies, it is banking companies and non-banking non-financial companies, or it is none of the above. This question is somewhat trying to confuse you, like whether it is banking, but if you apply a bit of common sense, you can answer these questions well, because the sets that have been picked here is something, the options options itself speak for themselves, that you can guess also that banking and non-banking, whether it can be together. Okay, so the answer for this is B. That was non-banking financial companies. Banking. B option is both A and B. Okay. B option is both A and B. That is banking companies as well as financial companies is the answer. That is provided on and after the commencement of the Companies Act 2013. No company shall invite, accept or renew deposits under this act from the public except in a manner that is provided under this chapter, provided that nothing in the subsection 1 of section 73 shall apply to a banking company and a non-banking financial company as is defined in the Reserve Bank of India Act 1934. So this provision specifically provides for the answer. So Consolidated Fund of India, that is section 15JA of SEBI Act 1992 directs that the funds are to be credited to the Consolidated Fund of India. Okay. Now the next question, that is question 13. Question 13 says that which of the following can be considered as the main object of the Securities Contract Regulation Act 1956. Which of the following can be considered as the main object of the Securities Contracts Regulation Act 1956? The options are descriptive. Read the options carefully, that whether the following can be considered as the main object. The first one is to protect the interest of the investors and promote and develop the securities market, to prevent undesirable transactions in securities by regulating the business of dealing therein, to control the monopolistic and restrictive trade practices followed by the listed companies, to consolidate and amend the law relating to companies and certain other associations, to control the monopolistic and restrictive trade practices followed by the unlisted companies. Answer: because the Securities Contracts Regulation Act 1956, that is an important piece of legislation which gives central government the regulatory jurisdiction over these three areas, that is stock exchanges, contracts and securities, and listing of securities and stock exchanges. This is specifically provided, and SEBI Act, main object of this SEBI Act is something which is very important. SEBI Contract Regulation Act 1956, very basic question that can be asked, and something which you have to be very clear, and such questions you have to, which are more descriptive, you need to read carefully and answer them calmly, and don't get nervous because these are actually easy questions, but because they are very descriptive ones, so they look difficult. Okay, so be aware of such kind of sections, such kind of questions also. Now 14th question, that is the short term deposits are repayable not earlier than how many months from the date of such deposits or renewal thereof. So this is talking about the short term deposits, and they are repayable but not earlier than how many months from the date of such deposits or renewal thereof. The options are 13 months, 3 months, 23 months, 33 months, or else none of the above. The answer is 3 months. Rule 3(1)(b) of the Companies Acceptance of Deposits Rules 2014 provides that such deposits are repayable not earlier than 3 months from the date of such deposits or renewal thereof. Now this is again a direct question, and this is something which is different that can be asked. So this question has been picked up here. Deposits and when they are repayable and when they are not repayable. So we need to keep in mind such kind of questions. The last question for today's discussion, that is the 15th question, again that has been picked from the SEBI Act. Now be aware of these questions because SEBI, company law, all these hold a lot of weightage and more number of questions are expected from these areas. So we need to discuss more questions on these areas. That's why I have picked up 2-3 questions from SEBI only for today. On which date did the SEBI Act 1992 come into effect? 30th January 1992, 1st April 1992, 31st March 1992, 31st December 1992, or 19th November 1992. Now, the day of commencement, that is coming into effect actually. So this SEBI Act holds a lot of importance, this entire legislation. So the commencement date of this act you need to keep in mind, and such questions you cannot guess. So answer will be A, that is 30th January 1992 is the date on which SEBI Act had come into force. Okay, so we have covered 30 questions up till now from the set of 50 questions that picked as important questions covering almost important areas this new year. Thank you. Have a nice day all. Enjoy studying. Stay safe. Stay calm. Bye bye. Goodbye.